these matters will appear. 2 weeks, this bench will not sit. So after 4 weeks, all the matters will appear. Give it. Any mentioning for inclusion, please hand over the slip. It will appear after 4 weeks.
It is for the final hearing, my lord.
Yes.
Your lordship has pleased to.
Whatever it is, please hand over the slips. Any Xerox copy is there?
No, because the death certificate has been applied for. It will take 2 to 3 months.
Okay, leave granted. Just wait a minute. Any outside the list?
My lord.
Yes, please give the slip. Yes, now inside the list mentioning.
My lord, item number 18 of my lord's today's list has to be mentioned. Item 18.
Yes.
My lord, this is a disposed of appeal.
Yes.
My lord, pursuant to the disposal order, claimants have withdrawn the money. Some excess money is lying with the registrar, my lord. I am the insurance company. My lord, I seek a direction from your lordship that money be given back to me, my lord. My lord,
So other side is not present.
so, my lord, whether today or when my lord comes back, whenever my lord pleases.
Yes. So
Other
let
side
it
please.
appear. Okay, you mention whenever thereafter.
My lord,
It will remain in the list.
lordship.
If you bring the other side, I shall take it up.
My lord.
Yes. 49, yes.
ठीक है तो उधर में चिट्ठी दे
But this is a matter.
वो पैसा लिया है कि नहीं लिया है कंपटीशन है बाबा हमसे झगड़ा क्यों कर रहे हैं जैसा तो झगड़ा कर
Creation for lordship.
हम तो बोल रहे हैं
Action be held in presence of special officer. Honorable court, the respondents have not.
Anyway, the matter will be heard some other. Yes, you are appearing for? Appellant, you are appearing for? Yes, if both of you are agreeable, I can release the matter. No, if both of you are agreeable. No, I have already fixed up. No, in the meantime, in the meantime, what is the urgency? That you cannot wait till 17th. No, just 17th. Yes, in the meantime, why you cannot wait? Yes. No, that will come up.
Mike bol na Mike.
Lordship. Without informing us, they mentioned the matter again, your lordship.
Lord, I said, Lord, 17th, Lord, I have some difficulty, Lord, I will not be here.
Achha, to be mentioned.
Lordship fix the matter.
Achha, I can do one thing. Let this matter. Achha, order kono order hoy ni tale. Achha, record an order. No. What do you want? Do you want me to fix the matter on a particular date, or do you want the? Yes, record an order. Learned advocates for the parties are present. As by consent of the learned advocates, the matter be fixed on 17th or 18th.
17th, 18th, that week, Lord, I have some difficulty, Lord.
Okay, 16.
Next week, Lord, next week.
Okay, 21/9/2026 at 2 p.m.
My lord, the administration.
21.
My lord, the administration of the mott is in bad hands, your lordship. That is our case, your lordship.
Okay,
They
21.
are trying to prolong it, your lordship.
In the 21. In the meantime, if there is some exigency, you can obtain order from the bench. We will be having determination.
This is a hearing matter, your lordship.
Maybe, but if you want some interim relief. Okay, 21/9/2026. Huh? At 2 p.m.
At 2 p.m. your lordship. Great.
May I have my lords kindly to mention item number 17, my lord. 17, my lord, will kindly refer the matter to Lok Adalat, my lord.
Yes, record an order. Hey, order. Learned advocates for the.
We both are here.
Okay, learned advocates for the parties are
Chotero.
present. It is submitted by the learned advocates that there is a chance of settlement in this matter, and the matter may be referred to Lok Adalat. Thus, this matter is referred to the Honorable Lok Adalat to be held in the month of September. Fix 21/9/2026 for report of the Lok Adalat and further order.
My lord, deeply obliged, my lord. আমি অ্যাপেলেন্ট
আপনার other side এ
Affidavit of service. Yes, man, item number 1. Now, this is my affidavit of service, my lord.
I am for the opposite respondent.
Which application?
Now, this is application for section 5, my lord, application can 1.
9 to 4 days.
You are for all the parties.
My lord,
Plenty of response.
before your lordship starts, my lord, I should be very candid, my lord. There is a delay of 924 days. My lord, the ground has been taken, my lord. My lord, the appellants before your lordship, my lord, are very, my lord, poor persons, my lord. They reside in a village, my lord, and my lord, they do not have any idea. My lord, I have taken a ground of my lord, rustic village, my
Did
lord.
you file any opposition to this?
No explanation in the.
My lord, I am only carrying
No
a division
explanation
bench
of the-
judgment of this honorable court.
Not only
If-
single days.
If the, my lord, the appellants are rustic village, my lord, persons or women, my lord, they have a right to file an appeal. Well, whatever, my lord, in the reasons, my lord, I cannot be outstated in the threshold of the, my lord, in appearing in this court, my lord. That is the main point. Well, if your lordship kindly considers, my lord, paragraph
Case,
3,
sir,
4.
explanation must have been done. Lord, the since the appellant.
Yeah, my lord.
petitioner is-
Paragraph
Yes,
seven,
appellant-
paragraph 7 and
appellant.
8.
My lord, paragraph 6, 7 and 8. 7, 8 and yes, 9.
7, 7, 8.
Yes. My lord, paragraph 7 and 9, 8, my lord, I have specifically stated. Judgment to din. Judgment dilam jamna.
An applicant is the appellant.
My lord, lordship will kindly judgment copy ta আমাকে এটা বের করো।
So, traffic is so,
Yes.
no.
Sure. My lord, paragraph 4, my lord, if your lordship sees, my lord.
Yes, you have not filed any opposition to this, but you are opposing.
I am opposing them.
Yes, record an order.
My lord, only difficulty is that, my lord, in the meantime, my lord, execution cases, my lord.
What can be done? You see, you have come at a belated stage.
My lord,
Yeah, I
only
like to file a opposition.
So you want to file affidavit in
the
opposition.
division bench judgment is, my lord,
When
square.
is the date fixed for execution?
My lord, it's pending, my lord.
No, when is the next date fixed?
Next date, my lord, I have to take, but my lord,
Yes, learned advocates for the parties are present. Hard learned advocates, learned advocate appearing for the respondent intends to use an affidavit in opposition to the application filed by the petitioner appellant. Such leave is granted. Let the affidavit in opposition be filed on or before 1/9/2026. Reply, if any, by 8/9/2026. Let this matter appear on 10/9/2026. Stop. As the matter is sub judice before this court, the parties may seek adjournment before the learned trial court, and the same may be considered.
grateful, my lord.
My lord, the Venal lordship is disposed of here now.
Yes,
If your lordship is granting adjournment before the landed court below.
yes.
Then lordship is
But you have
disposed
not filed your affidavit in opposition. How it can be disposed of?
of. Let the dispose of here now.
You want the disposal,
Yes.
but you are opposing. So let that be
Things, my lord.
recorded.
My lord, the opposing, my lord, since there is no explanation at all. My lord, this is
7 and
not
8.
Acha,
question of
okay.
single days.
Learned advocates for the parties are present. Hard learned advocates. The appellant in the instant case has sought for condonation of delay
No
Of-
explanation.
Paragraph 7 and 8, my lord.
of 924 days. This application is opposed by learned advocate for the respondents. Learned advocate for the respondent submits that the appellant has not furnished any grounds for condonation of delay, save and except that they are rustic villagers.
The appellant is the applicant.
Appellant.
Appellant is the applicant.
A learned advocate for the appellant relies upon a decision of this honorable court. Report in the case of Sri Subhashish Mondal versus Union of India, reported in 2017 SCC Online Cal 4612.
My lord, paragraph 4 onwards, my lord.
Paragraph 4, my lord.
That is, there is explanation is must.
No. স্যার এটা দেখুন কি লেখা আছে ডিভিশন বেঞ্চ
আরো না তুমি No, তুমি তো হচ্ছে
Yes, in the said decision, although the delay was condoned on the ground that the appellant was a rustic villager, but in the instant case, considering the period of delay, which is 924 days, this court is of the view that this delay should be condoned subject to the payment of costs. Thus, this application under Section 5 of the Limitation Act stands allowed, subject to the payment of costs of rupees 2,000 to the respondents and rupees 1,000 to the West Bengal State Legal Service Authority on or before 9/9/2026. Let this matter appear on 10/9/2026 for the compliance report. Yes, as I'm giving the same condition as the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
Grateful, my lord.
For the petition, my lord.
Yes. Yes, yes, where is the respondent?
I am applying for the opposite pad number 1. Legal yes of the opposite pad number 1.
My lord, this is the section can number 4, my lord, for restoration, my lord. And this is the affidavit of service, my lord, I have filed.
Was any affidavit in opposition used?
Yes, already filed. Or reply also filed, lordship. And fixing the date or lordship here around now. Here this matter.
Affidavit of service.
You are the plaintiff appellant.
No, petitioner, revisional application.
Before the trial court, he is a plaintiff.
Yes.
Petitioner because it is a preemption case.
Oh, that means a petitioner before the trial court. So you have lost both in the trial court and in the appeal court.
My lord.
You being a petitioner, filing the preemption application, lost in both the courts. So this is a revisional application.
And my lord, this is for the restoration, my lord. The latches on the part of the earlier advocate, my lord. For that, my lord, the petitioner is suffering. And my lord, the kindly see the matter has been dismissed for default due to non-filing of my lord substitution application, which has been my lord allowed last day, my lord.
No, substitution application.
Substitution application has been filed. That has been allowed on 3rd August 2026. Your lordship allowed. And for that, my lord, the
It was thrice dismissed, lordship.
Okay, just a minute. You see, there is an order. You see, that
Lordship, I can.
no, that this application was adjourned with liberty to parties to mention for enlistment after the special bench gives the decision. The matter is still sub judice. So you see, is the special bench decision taken? Has the decision been taken by the special bench?
No. This issue was not involved.
No, 3206, this revisional application. An order was passed on.
On?
You may go through this order.
Lordship, order dated?
I don't know whether you have, because some 2011, July 2011. Order passed by Justice Showmention.
Yes. Thereafter, revisional application was dismissed.
Maybe, but you see, this matter cannot be taken up also because
my lord, only restoration, my lord. The matter may be
Restoration,
restored, my
no, lordship, 3 times dismissed. Lordship,
My lord,
that's a different issue. Is it filed within 30 days or after 30 days?
first restoration, no.
I just confined this
within time,
application.
my
No,
that has
lordship,
been filed.
first restoration filed 1 day's delay.
That restoration, lordship asking. That
No.
restoration within 30 days.
No, first lordship, kindly see the list of dates, also the relevant orders of the Honorable Court. Kindly see. First it was dismissed on 2012.
Okay, let me see this dismissal order, please. Yes, this was on 5/7/2024.
My lord,
Okay, so it is filed in time.
my lord.
So what is the ground of dismissal? Not present.
Not present, my lord. This surprisingly, the bench was sit, my lord, and advocate was not appeared. And my lord, also there is a direction from the honorable judge to file a substitution application. That has not been filed, but that has been filed before that order has been passed.
So we,
Your lordship allowed that order on 3rd August 2026.
Lordship, before, Lordship, kindly go through the order dated 5th, 7, 2024, enter order.
25/5/7/2020.
Lordship, enter order. Also decided that the already execution was done. So revisional application have no force, Lordship. Kindly, I place this order. The petitioner is present.
My lord,
Though the
if
opposite
that
party
be
are
so,
present.
my lord,
presented by the
kindly restored the matter.
How?
And after
Okay,
hearing,
let me see your opposition, okay?
Yes.
এই অপোজিশনটা বার করে দিন।
my lord, when the opposition has been filed, they are not substituted. My lord, that point I have taken, my lord.
No, substitution application is filed after this restoration.
My lord,
Substitution application was filed after
no,
restoration.
my lord,
Before.
before.
Okay.
My lord, that has.
And
not
you are
been legally
representing
noticed.
all the parties.
No, opposite legal of heirs of the opposite party.
No, but
Opposite
the
party
audio,
number one.
One.
there was only one opposite party.
No,
No,
three.
there is 3 opposite party, but the 2 and 3 are not interested because they are the seller.
So you are representing the heirs of opposite party
Opposite number
number 1. 2 and 3 have not appeared.
Not
My
a-
lord, they have appeared
No,
after,
in this revisional application.
no, until my lord 3rd August.
না এর অপোজিশনটা রেস্টোরেশন অ্যাপ্লিকেশনের অপোজিশনটা দিন।
opposition lawsuit can 4 against the
Yes.
can 4.
না ক্যানফোর্ডে যে ওই যে অপোজিশনটা দিয়েছে আর কি।
Paragraph number 4.
Yes.
Factual aspect I already stated, lordship. B is there, lordship. B. Entire order sheet. I also annex the entire order sheet.
No, the date was the dismissal order was passed by Justice Bishas.
Lordship, I
But you have stated Justice Mondol
lordship.
in your opposition.
A.
Name is same, but the surname you have
4A,
changed.
4A, lordship. Last.
The name is same, but the surname you have changed.
No, Honorable Justice Proceedings Mondal.
Yes.
Last portion, 4A.
So it is not dismissed by Justice Mondol, probably.
Yes.
Yes, 2024 Justice Mondol was 2000.
Initial dismissal order is 2012.
Oh, no. Okay, this the last order.
Initial order of dismissal 2012. Lordship, kindly give me the list of dates. Also, I
My lord, the matter
annex
has
the
been
whole order.
dismissed in 2012. Thereafter, restoration application has been filed. That also, my lord,
kindly, Lordship, on 13/12/2012,
12, then again dismissed for.
Honorable Justice Proceedings had been pleased to dismiss the said revisional
No,
application.
thereafter it was restored.
No, that
That-
restoration application also dismissed.
No, that
Restoration application filed on 14th January 2013.
With I know what happened to that. Okay, so far Justice Prosenjit Mundo.
That order, till date, that order was not restored.
No,
That application also dismissed. Lordship,
no, why is that
next order, Lordship, 16 January 2024. Kindly see the order.
No, then you see, if that is not restored, that application is not recalled, that 2012, then subsequent orders, dismissal or any other direction, all are a nullity. If that order is not recalled.
No,
So 13, 12,
no,
2012.
Lordship, kindly see the 16 January 2024 order. 16 January 2024. I annex also
So if
order.
his lordship heard the matter, but the question is 13/12/2012, the order of dismissal was passed by Justice Mondol. Okay. Now, if the dismissal order remains, okay, the subsequent orders, hearing and direction, all are nullity.
Yes.
So the question is, was an application filed?
File,
to-
my lord.
File.
So
that
let
was
us see that
dismissed.
application.
Application
That was
filed.
dismissed.
Where is that order?
Lordship, 16 January 2024.
16
the
January
can-
2024 is revisional application is
No, no,
dismissed.
no, kindly see, Lordship. 16 January 2024. I already, my list of dates also order also annexed, Lordship. Honorable Justice Proceedings বিশ্বাস.
So on 16/1/2024, your restoration application was
20th February,
yes,
Lordship,
yes,
2024.
16/1/2024.
No, next order, next order,
Thereafter.
Lordship, 20th February 2024.
Okay, let us see. 20th February 2024.
24. Top can 1 of 2013. That application, Lordship, dismissed,
Yes, dismissed by a default.
Lordship, without restoring that application.
Okay, no. Just with a prayer for no. An application was taken out. What is that? Where is that application?
That can one,
Can one?
can one.
No, but the ground is this.
My lord, what happened, my lord? The earlier, the fault of the earlier advocate, my lord. And for that, my lord, the petitioner should not be suffered.
They then file another restoration. That was also dismissed.
No, actually, so one restoration application was filed against the dismissal order dated 13/12/2012. That is probably can one of
10 of
2013. Can 1 of 2013.
2013. Okay.
Yes.
So can one of 2013 was dismissed.
On 22 2024.
Okay. So what is the
Then file a restoration.
that is you see can 4 of
Present can 4.
can
Thereafter they file an restoration
just let
application.
me see what is the ground you have stated for this dismissal.
Dismissal, Lordship, kindly see
What
20th
is the
February
ground for not being present?
2024. Order of the 20th February 2024, Lordship. Second paragraph, second paragraph, it appears that the institution was dismissed for default by an order passed by this court on
my lord,
13
paragraph
12,
4,
and
my lord.
against the said order of dismissal, an application was taken up on behalf of the petitioner with a prayer for restoration of the said application.
13/12/2024 or 2012 it should be.
Yeah, restore
Anyway, thereafter what happened? 16/1 the matter was heard.
20th February
So 16/1 he was present
16/1.
when the matter is
Yes.
16/1 he was present.
Present.
So 22 2000.
24. Next order.
Okay.
Second paragraph, Lordship.
Okay. Thereafter 22/22/2024
None
was-
appear.
So this is the ground you have stated regarding that you are misled by the matter appearing in the list. Para number 8.
Thereafter, Lordship, another restoration application.
So this is within 30 days. Yes. What is the other restoration? Can 1. Let me see that.
Can 1 out of time, Lordship, but no explanation was given.
Let us see this.
Can 1 of 2013, Lordship.
Can 1 টা দিন তো একটু। Can 1 এর disposal নেই। Anyway, by consent it can be taken up.
Can one also dismissed by the order dated 5th July 2024.
20th of February 2024.
That means
That is here
that is
from
no, if that is restored, that order is recalled, your can 1 is restored. Thereafter the can 1 can be taken up. Can 1 টা একটু দেখি। Can 1 টা can 2 3 আছে। You have a copy of can 1,
Yes, I have a copy.
please.
Certificate copy তুলতে হবে।
Nothing was stated, Lordship.
Can
2013
How many days delay was there in this?
1 day.
Huh?
1 day.
1 day.
But should be mentioned or grounds of restoration.
Knowledge, have you stated any regarding knowledge that when did you come to know? Huh? 1 টা এটা দিয়ে দিন ওটা এটা can 1.
And
Yes, record an order. Anything else?
no, thereafter, Lordship, second restoration also dismissed.
This is that for which this can 4 is filed.
No, that is third.
This is third.
Yes.
So second restoration.
Second restoration is can 2.
Let me see that.
Can 2 was dismissed. Can
Better you give me this can 2 and can 3.
Can 3 has the substitution
Okay,
application that is
can
allowed.
2, can 1 is for the restoration of the this revisional application,
My lord.
and can 4 is restoration of your can 1.
no,
My
that
lord,
was not paid.
my lord, what
that
happened?
is not fair.
My lord, what happened? The revisional application has been dismissed along with can 1 and can 2 as dismissed, my lord.
Can 1.
By the
Can
order
1
dated
first
5th
restoration.
July 2024.
Can 1 is the first
Under the
restoration.
second page, my
Can
lord.
1.
Can 2 is the second restoration. That was also dismissed. That was dismissed on 16/5/2024. Pageant restoration is can 4. Nowhere
My
praised
lord,
that
in 5th July
the restoration of that
2024, my
application. Nowhere it was stated and also not prayed that the can 2 order and can 1 order was recalled.
আচ্ছা একটু বলতে দাও। My lord, in 5th July 2024 order, page 2, paragraph 7, my lord, kindly see. In view of dismissal of the main revisional application because the paragraph 6 revisional application has been dismissed. The order dated page 2, 5th July 2024 order. Can 4, my lord, the order. Can 4, my lord. My lord,
Can 4 along with Can 1 and Can 2.
my lord,
You wanted that Can 4 to be taken up along with Can 1 and Can 2.
because my lord, the revisional application in page 2, my lord, paragraph 6, the same being number such and such dismissed for default
So what have you prayed for in Can 4?
for restoration of the revisional application.
That no, 5/7/2024. 5/7/2024 is this your restoration application. Can 1 goes. Probably Can 1 and Can 2.
My lord,
Yes.
Can 1 and Can 2 along with my lord revisional application.
Yes, revisional application already gone. Okay. So unless Can 1 and Can 2 is allowed, your revisional application does not become alive.
That was
So,
not prayed.
so Can 1, okay, when
My
revision,
lord, I am praying for recalling of the order dated 5th July 2024.
yes, 5th July 2024 is your Can applications are dismissed. That
Al-
is, yes,
and
5th July.
And also, my lord, the revisional application.
Yes, no, that cannot be. You see, divisional application is already dismissed. Even if this observation is made, it is of no use.
My lord, what happened actually, my lord, the honorable judge
Okay,
was
application.
surprised about the
Anyway, so that is a nullity. Once a divisional application is dismissed, any order passed in that application is a nullity.
my lord,
Yes, only it can be passed under this Can 1 or Can 4,
Fine.
this two. So far your Can 1 application is concerned, that is for recalling the order passed by Justice Mondol, that is
2012.
2012.
That is, what is the date?
Lordship,
Third.
date of dismissal date of 13 December 2012.
13th December 2012. Okay, first dismissal.
First dismissal.
Okay,
And second dismissal, Lordship,
first dismissal of
That-
this revisional application.
My lord.
revisional application. Thereafter, Can 1 restoration, that was also dismissed on
Okay,
20th.
so for which Can 1 of 2013 was taken out.
Taken up.
Can 1 of 2013.
My lord,
That-
old
that was-
number is
Okay, for
364.
restoration.
Restoration, that was,
Now what happened to that application?
that application was dismissed on 20th February 2024.
20th February 2024.
2024.
Let us see that order. Have you annexed that order?
Yes, yes.
20th February 2024. You have a copy of that order? Okay, let me see in your list of dates.
Yes, I annexed this order, Lordship.
20th February, 16/1. Oh, not 16/1.
Page 8, Lordship.
Okay, 20th February 2024. Okay.
Lordship.
So
Second paragraph.
just let me see.
Second paragraph, it appears that the instant revisional application was dismissed for default by an order passed by court on 13th December 2012, and against the said order of dismissal, an application was taken out on behalf of the petitioner with a prayer for restoration of the said case. Thereafter, Lordship, last portion. Accordingly, the present revisional order being hereby dismissed for default, but no order has cost, and the application
No,
also.
this is of no use because revisional application is dismissed. Where is the dismissal of this Can 1?
Can one of that was observation?
No, there is no dismissal of this Can 1. So unless that is not there, Can 1 can be dismissed. But this revisional application, once it is dismissed, it cannot be dismissed again.
Then
So the order is a nullity.
then Lordship, kindly come to the order
27/3.
on input or Lordship, 5th July 2024.
5th July 2024. 16/5.
Paragraph number 7, Lordship. I annexed the
Paragraph
my
number 7. 5/7/2024.
Lordship 5/7 2024.
Yes.
Paragraph number 7, last portion.
However, you see, except
In view of
Can
the
3 is for what? No, Can 3 is substitution. Can 2
Can
Can
also
do for
restoration.
Restoration application
of that Can 1.
of that Can 1.
In view of the dismissal of the main divisional application, the connected being Can number such and such, and Can 1 and Can number 2 are also dismissed for default.
Anyway, Can 1 is for restoration.
Can 2 also
And
restoration.
Can 2 is restoration of that Can 1.
Lordship.
And Can 4 is restoration of Can 1 and Can 2, as well as the revisional application.
That was not prayed. That
My
was
lord,
not
here,
stated.
my lord, I have prayed, my lord, for recalling of the order dated 5th 7 2024, as my lord, the honorable judge was not apprised about the filing of can 3 application that has been filed prior to the dismissal of that.
Okay, what grounds have you stated in can 2? Can 2, what grounds have you stated?
Can 2 lordship,
My lord, paragraph 4, I have stated the
Have a copy, please give.
Paragraph 4, my lord.
Yes. Yes, anything else?
no, my submission is the last can 4 can be allowed if they prayed for restoration of the can 2. Can 2 can be allowed in restoration of the can 1. But to that extent, in the application, nothing was stated in the body, also not in the pair portion.
Yes, record an order.
Second thing, lordship, the revisional application already in process. Because of that, the order of the appellate court already executed.
Now the question is, suit is disposed.
Suit was disposed, appeal was disposed.
Anyway,
Thereafter, I file an execution.
that can be decided at the time of hearing the matter on merit.
Execution already completed.
Very well. The
Legal
matter
opposition was
the matter can be decided on merits. Learned advocates for the parties are present. Hard learned advocates. Upon hearing the learned advocates and perusing the matters on record, it appears that the instant revisional application CO number 3206 of 2009 was dismissed for default on 13/12/2012. Stop. Pursuant to the dismissal of this application, an application for restoration being Can 1 of 2013 was taken out for recalling of the order dated 13/12/2012. Thereafter, on 16/1/2024,
20th February.
okay, 22/2024, the application, it was by order, it was observed that the revisional application dated CO 3206 of 2009 is dismissed for default. However, there is no observation with regard to Can 2 of 2013, which was filed for recalling the order dated 13/12/2012. Thereafter, the appellant petitioner took out this application Can 4 of 2024 for recalling the order dated 5/7/2024, where a learned judge of this court was pleased to dismiss the revisional application CO 3206 of 2009 along with Can 1 of 2013, Can 1 of 2024, and Can 2 of 2024. Upon considering the applications, as a learned advocate for the opposite party vehemently objects to the prayer of the appellant on the ground that thrice these applications were dismissed for default. Upon perusing the petition and considering the grounds furnished in the applications Can 1 of 2013 Can 2 of 2024 and Can 4 of 2024, this court is of the view that in the interest of justice, the appellant has shown some grounds for not being present on the date fixed. However, this application should be restored subject to the payment of costs. Thus, this application Can 1 of 2013, Can 2 of 2024, and Can 4 of 2024 stands allowed. The revisional application CO 3206 of 2009 stands restored to its original file and number, subject to the payment of costs of rupees 1,000 to the opposite party and rupees 1,000 to West Bengal State Legal Service Authority on or before 9/9/2026. Let this matter appear on 10/9/2026 for compliance report.
Fine. My lord, in the order, my lord, your lordship directed the appellant, my lord, that will be petitioners.
আচ্ছা, অ্যাপেলেন্টের জায়গায় পিটিশনার করে দেবেন, যেখানে অ্যাপেলেন্ট আছে পিটিশনার করে দেবেন। Can put dispose the CO this revisional application is restored to its file.
There was a,
for the petitioner.
there was a direction for filing a report, my lord. We have
Yes, for
received,
compliance report.
my lord, we have received the information very late. It has been complied with.
Let us wait for the compliance report. May let it be taken up in other day.
Yes,
Subject.
record and order. Learned advocates for the contemner respondent submits that the order dated have, yes,
The third 10/2025.
3/10/2025 passed in WPA 23395 of 2025 is complied. Learned advocate for the contemner respondents prays for time to file affidavit of compliance. Thus, this matter stands adjourned till 11/9/2026 for filing affidavit of
Grateful.
compliance.
My lord,
Yes.
in item number 4, my lord, I am appearing virtually. I beg to appear on behalf of the petitioner, my lord. My lord, on the last occasion, your lordship was pleased to direct me to effect service upon the alleged contemner, my lord. My lord,
Yes.
we have service, my lord, but my lord, that has been refused by the alleged contemner, my lord. My lord, let me tell your lordship, my lord, concerning the my lord, initiation of this contempt proceeding is that, my lord, your lordship was pleased to, my lord, pass a direction upon the Pradhan to, my lord, consider the representation, my lord, with regard to a illegal construction as alleged by me. Milord, that has not been complied. Milord, where from it appears, Milord, that Milord, the contemner, Milord, has taken your lordship generosity and tolerance as a matter of right.
No, today it is appearing for some correction. The
No.
matter is appearing.
As far as item number 4 is concerned, Milord,
Yes, it is appearing for some correction. আগের ডেটে কি অর্ডার দেওয়া হয়েছিল?
lordship only sees the last order.
Oh, contemner. Yes, anybody appearing for contemner respondents?
Milord, we have served. That has been refused.
Last occasion.
Last occasion, it was for the direction to issue notice. So we have issued. Dot sahib ke ekটু এটা দাও, খামটা দিয়ে দাও।
না খাম সমেত দেখি ওটা রিফিউজ হয়েছে তো। Yes, record and order. Learned advocate for the petitioner is present. Do you file an affidavit? Okay.
Milord, affidavit is ready but not affirmed. I will file it within the
Okay.
court.
The learned advocate for the petitioner submits that the contemner respondents have refused to accept service of notice and have produced the return envelope. Let an affidavit of service be filed. Let this matter appear for orders on 11/9/2026.
Millard,
Huh?
on 11th, I will be filing the affidavit or today, Millard?
Get it ready, file it on the, yes.
Very well.
That's it.
Grateful to your lordship.
কোথায়? কোথায় লিখেছে? Oh. আচ্ছা, in the meantime, the necessary correction of order dated 31/7/2026 be effected in the cause title.
Grateful to your lordship.
I, my lord, for the appellant.
I appeal.
I have already concluded my submission and I
You submit,
supplied the written notes of argument also.
actually, that is the learned advocate, your predecessor, you may say, submitted on the issue of section 80 of the Code of Civil Procedure. His submission was confined to that section. Section 80 was not complied, so the suit is not maintainable. So you may
Lordship,
prepare your submission on the way.
Lordship, what I find going through the suit, Lordship, the section 80 was not complied with. If in neither of the judgment, in the written notes of argument, my learned friend has raised the issue of section 80, subsection 2, that it was filed. So the leave should have been granted prior to the suit, but it doesn't appear from either of the judgments that there was any attempt or the appellate court had gone through the records of the lower court to find whether there was actually any order relating to subsection 2 of section 80. Lordship, that is not evident from the records.
That his submission was
That is
with
his submission
with regard
now.
to the decisions on this aspect.
Lordship, his submission now is relating to, from the written notes of
Section
submission.
80.
Section 80, he says that on the same day, Lordship sees paragraph 2, subparagraph 1 is on 21st of December.
That is appellant's written notes of
Appellant's
argument.
written note. He says, I filed.
That is on record, but
That is on
but so
record.
for respondents, it will not be in the record. So what I remember, I told you.
Lordship, the respondent's lordship, it's whatever is on record, Lordship. I cannot go beyond that. Whether the suit
Actually,
is
no
there,
relief is
but
actually
there's
sought.
actually no relief, Lordship.
No relief is sought from state authority.
Even whatever decisions my learned friend is relied upon, Lordship, it is like one was a suit for issue of letters of administration. There an application was filed for a presumption of death of one particular person. Therefore, Lordship, this suit actually, there is no relief. The court below had said you should have gone under.
Because actually, you see, section 80, when relief is sought against the state authority, had that been produced the report, find out the person, all these things.
So nothing has happened.
That is, you see, that relief is not sought. Simplicity or a declaration for the civil rights. As you know, in different railway claim cases,
yes, Lordship,
the similar problem arose.
similar problem in your Lordships had passed it.
Yes, that is only confined to that. So
Confined.
only for the civil rights, these
Yes.
persons are seeking declaration, not asking the state to give some relief.
Exactly, Lordship. And in this particular case, Lordship, the question is that whether any relief can be given. That is
Seven
also-
except that declaratory.
It's declaratory that we have that much. Lordship, one thing, Lordship, I suppose, without being too technical, Lordship, since I'll just ask the state if they could give a report. I think then
At best till today,
best till today.
that would be the best
I
thing.
think
Till today.
let the matter be ended.
And
Instead of us going into all the legalities.
thereafter you file your report and whatever you want to cite your judgment.
Whatever, yes. I think I'll do that.
Yes, record an order.
I think that will be the best.
Learned advocates for the parties are present. Learned advocate for the appellant has concluded his submission.
Yes.
MS Alam has prayed for time to obtain a report from the state authorities with regard to the facts of the case and whereabouts of the victim.
Lordship.
Let such report be obtained and let the written notes of arguments be filed on the next date fixed. Let this matter appear on 11/9,
I'm trying to find.
11/9/2026.
But a time may be fixed, my lord. and
So let it be not Friday, some other day.
Then late.
Okay, 15/9/2026 at 4 p.m.
Lordship. Okay. I think I'll. That will-
But before the learned court, bolo, they have filed the report
Anyway, till today.
till today. Yes, yes, yes. Yes, court.
Although you see, in second appeal, it is purely on the question of law.
Oh,
One has to finish something.
Yes,
I think
under an inherent power only that,
the substantial law, substantial question has also been framed like that.
because if that report is there, the case
Then
goes.
the whole thing goes. That is why.
Anyway, report and your written
I'll
notes.
give a report and let's finish the matter here only.
Yes, yes.
grateful, my
Otherwise-
lord, grateful. Thank you. হ্যাঁ হ্যাঁ দিদি।
Yes.
Milord, written notes are furnished.
So conclude the hearing.
Milord, hearing had been concluded. Your lordship only asked us to file the written notes today, Milord.
This is with regard to that.
Milord, bouncing of the premium check, Milord.
Yes, record an order. Learned advocates for the parties are present. Hearing of the matter is concluded. The written notes of arguments filed only by your learned friend.
Milord, I have also
So
filed.
by the learned advocates be kept with the record. Let this matter appear for judgment on 15/9/2026.
15th September. Obliged, your
15
lordship.
তারিখে কি জাজমেন্ট? আচ্ছা তাহলে এটা ইয়েতে
হ্যাঁ।
থাক। না 17/9/2026.
Milord, written argument filed by both the parties.
Yes, that is the written notes of arguments filed be kept with the record.
Grateful, your lordship.
My lord, I am for the appellant. My side of argument as well as written argument already filed, my lord. It's a part-heard matter, my lord.
ফাইল নেই এখানে? Okay.
It was a part-heard matter. My part
Anyway,
was already
next
com-
day, let it appear on the next day.
the
দেখুন
date
কবে
may
কি
be
আছে।
fixed, my lord.
না একটা ডেট দিই দেখুন কবে খাল। হ্যাঁ
Next day.
ফাইল পেয়ে ফাইল না পেলে অর্ডার রেকর্ড হবে। Anyway, just not today.
Not today.
If the file is traced out, it will be listed.
My lord.
Milord, item number 8, Milord, this appeal of insurance company can be disposed of by way of a settlement order, Milord.
Yes,
Insurance
yes,
company would pay one time, Milord, 3,38,000. Your lordship will kindly record that money would be deposited and they have readied and accepted to accept the matter. 3,38,000.
3,38,000.
Lordship.
দেখি yes, take down দেখি record take two.
Is an against an award passed by the workman compensation. No money has been deposited as of now. We will deposit 3,38,000.
Learned advocates for the parties are present. This appeal was filed by the appellant insurance company challenging the order dated 6th May 2011 passed by learned judge Workmen's Compensation First Court West Bengal in claim case number 131 of 2007. Stop. It is submitted by the learned advocates that during pendency of this case, the parties have decided to resolve their disputes amicably. Stop. It is further submitted by the learned advocates that the parties have entered into a one-time settlement that the appellant National Insurance Company Limited shall pay the respondent claimant rupees 3,38,000
Grateful to your lordship.
as a full and final settlement of the claim. Full and final satisfaction of the claim. Stop. Satisfaction of the claim. In the facts and circumstances, nothing remains to be decided in the said appeal. thus appeal FMA of
FMAT.
F- FMAT FMAT 7 of 2012 stands disposed as being settled. Stop. Learned advocate for the appellant insurance company submits that the insurance company will deposit the compensation check within 8 weeks from the date of communication of this order. Let the compensation check be deposited within
Commissioner kache. Milord, my learned
before
friend says-
Register General.
Milord, I have got no difficulty. Milord, he says.
Yes, yes,
if
yes. Let it be before the register. The compensation check shall be deposited before the Register General, High Court, Calcutta, within 8 weeks from the date of communication of this order. Stop. The claimant respondent will be entitled to withdraw the compensation amount upon compliance of necessary formalities.
Extremely obliged, Your Lordship. I am grateful to my lord.
এবার কি আর কিছু আছে?
And I am for the petitioner, appellant. This has been disposed of. Only thing is that so far the appellant number 4 is concerned, during pendency of the appeal, she got married.
For that you have taken out an application.
I have taken out an
Can 3.
Can
দেখি can 3 টা।
I have annexed the Aadhaar card of the appellant number 4 also.
It is a disposed matter.
It's a
When it was disposed?
And it was disposed on just a second, Manav. This year only, few days back.
Okay.
Few days back.
June,
16th June.
Vacancy नहीं। Yes, record an order. Learned advocates for the parties are present. This appeal was disposed by judgment and order dated 16/6/2026. Stop. It is contended by the applicant appellant that during applicant
number 4.
Yes, applicant appellant that during pendency of the appeal, the applicant Malabika Khan, Malabika Naik, appellant number 4, is married, and pursuant to her marriage, she is known as Malabika Khan. In the Aadhaar card is also annexed to this application. In the facts and circumstances, this application stands allowed. Let the name of Malabika Naik be recorded as Malabika Khan.
May I correct
In
the
appellant number 4. The amendment be carried out within 2 weeks by the department.
By the department as okay. I am grateful. Much obliged. Can
Yes, can is disposed.
I am for the petition. This is extension of interim. Interim expire on
Item number 10, you are for the
petition.
Yes.
This is extension of interim order. Interim order expire on 2nd September.
You are for?
I'm for the HPCL, my lord.
Yes.
The respondent number 1 to 4.
All the respondents.
All the respondents.
Yes, record an order.
My lord, one thing I must indicate, our petitioner submission has been completed. Our submission at the verge of the disposal. We need to file the written notes of submission and the necessary judgments which we have to rely on. So a fixed date be given with a time fixed.
Learned advocate. Only written notes of arguments you want to file.
Along with the judgment, my lords.
Yes, yes. Learned advocates for the parties are present. The arguments of the writ petitioner is concluded.
concluded, I have to give the reply to the.
Okay. However, the respondents are granted opportunity to submit the reply, submit their opposition along with written notes of arguments on the next date fixed. Let this matter appear on 16/9/2026. 16 দেখুন টাইম কখন? হলো 4 p.m. 16th at 4 p.m.
Gratefully, Raj.
Yes, call 11.
Lord, I am indicating the corrections. Lord, Siddhartha, আমি indicate করে দিয়েছি.
Yes, what is the correction?
Let's have a look at this. I have indicated the
Yes,
corrections.
give that.
SA 93.
No, ওটা শুধু না. The order date has gone wrong.
Yes.
Instead of 27 July, it has gone as 8th May. And SA, instead of SA 93, it should be SAT 93.
SA 93, SAT 93.
And the order date has gone wrong. Matter was taken up on 27 July. And we are only one thing. The interim order, my lord, extended for 3 weeks. That has expired on 17th August. So let that also be extended.
Your Lordship, I strongly object to that.
Very well. Record the objection.
Yes,
kindly
record an order. Learned advocates for the parties are present. This matter is put up for necessary correction of order dated 27/7/2026. In the said order dated 27/7/2026, instead of the date being mentioned as 27/7/2026, it is mentioned, it is recorded as 8/5/2026. Let the rectification be made. Stop. In second line of the order, instead of SAT 93 of 2016 of the order, instead of SAT 93 of 2016, it is recorded as SA 93 of 2016. This mistake should also be corrected. Stop. The matter was directed to appear on 10/8/2026,
Yes.
but the said matter did not appear.
And the interim order was
Stop.
extended till
Learned
17th.
advocate for the petitioner prays for extension of the interim order, which is objected to by learned advocate for the respondent. However, as the matter cannot be taken up today and it requires hearing, the matter stands adjourned till দেখুন তো 10 তারিখে 10/11
সিদ্ধার্থ 10টা হবে না আমার 10 বাদ দিয়ে. Only I have some difficulty on 10th, my lord. I have taken an outstation brief.
দেখুন কবে আছে, but on the next day it has to be.
Lord, we will start our argument.
Yes, it has to be done.
Lord, the crux is that a 2197 application has been filed after 1 year from the date of obstruction.
And
Your
yes,
Lordship, no hearing will
16.
sought for.
16/8, 16. Yes, 69. You have been in difficulty.
No.
Okay, 69 at 12 p.m. 16/9/2026 at 12 p.m.
My lord.
The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
5 weeks মানে কতদিন হচ্ছে? আজকে কত তারিখ?
My lord, kindly fixes up the second appeal.
69, I'm keeping this. You mention it on the next day.
Divisions have to be decided.
No. Then it will appear you have given the slip.
Yes.
If you want, you give the slip. It will.
My lord, the order is there.
If it is there,
Order
it will. আচ্ছা এইটাকে সেকেন্ড অ্যাপিলের সাথে ঢুকিয়ে দেবেন, এই সেকেন্ড অ্যাপিলটা।
Mr. Mukherjee, if he has read the order says the revision will appear along with the second appeal.
So
If he has not read the order, what could be done?
Yes, এই সেকেন্ড অ্যাপিলটা ওই দিয়ে দেবেন, বুঝছেন, ওই স্লিপটা।
Let the second appeal be heard out. Then,
That order is there. I am asking them to put it along with this.
but it's not coming. Today it's not there.
Anyway, let the records be traced out.
That's why I have, on the lordship will recollect, I will already mentioned.
Lord,
এই রেকর্ডটা
today
পেয়েছেন
is
সেকেন্ড
the-
অ্যাপিলে?
But today, if the number has
particular
gone,
ইয়ে করে দেবেন।
Lord, today it has not appeared because the number has gone on record wrong. That is why it was not tagged.
Anyway, on that day it will appear.
And it was for correction.
What is the present situation, present stage of the mediation proceedings?
Mediation
Nothing,
has failed.
mediation has failed.
Okay, but I have to see the report.
Report has already
Report
come.
has come. Anyway, I'll see the record.
Report has
My lord,
already come.
Here the revisional application.
I
then
am the
second
landlord. I have been asked in the mediation, the offer was that I should pay them 2 crores to get my own property
Lord,
back.
these are to prejudice the honorable court. This is not required.
This is-
Mediation has
This
failed.
is the state
I
of
shall hear out the matter.
This should not have been.
state of affairs now,
not-
my lord.
After
I'll hear out the matter.
Yes, my lord. Kindly on merit.
After the Supreme Court judgment, this should not have been said in court. I can also say many things. I don't want to. Supreme Court says mediation failed is failed. Court will not go into that. So if he wants to bring that, I can also bring that. I'm not
You
doing
see, I'll
that.
not go into the mediation proceedings.
Yes,
I'll
take
just
up
see
the,
the report.
yes, take up the revisional and we'll have the.
That is all. That is sufficient.
That is all.
Yes, call the next.
It has
Therefore,
failed.
kindly hears up the second appeal. That will make everything clear.
Yes,
Very
yes.
good. I have the 2 revisions. We'll
Definitely it has to be heard out. Please come ready on that day.
On second appeal, I will come ready.
But I'll come ready on all the 3 matters.
13 said, let me see the last order.
Last order was for mediation, mediation failed, Lordship.
Let me see. Yes, record an order. Learned advocates for the
order of the Honorable Supreme Court.
yes, learned advocates for the parties are present. Today was fixed for filing of the report of the mediator. Upon perusal of the report, it appears that the mediation proceedings have failed. Let this matter appear on. Yes, let me see the order. The order to the
That with regard to other proceeding, not between the parties.
Supreme Court order.
Kindly see.
This case has been made the basis of the quashing application filed by the petitioners, and in
Is it
this,
with regard to this revisional application?
No, not
Yes,
with
your
regard to,
lordship,
not with
please.
regard to this revision application.
allow me
The
to.
subject matter is another FIR.
This FIR has been
She
made.
has to show the.
Case is Sanjukta Samant.
Yes,
Okay.
he's.
Where is that order?
She's the complainant here, caveator in person.
Another FIR, Lordship.
Her
She is
name-
placing another FIR
No, your lordship,
between the other party.
he
Her
has
husband is in.
Konat Shah.
Her husband.
husband has been accused in 78, which has been.
That is no, no.
That is different.
that
What is the
main
position?
of this CRR.
That one,
criminal
that one
revision.
shall hear.
Your lordship.
Lordship, trial court date is fixed on 15 September. Kindly prior to that, it can be heard.
Yes, yes. your lordship.
Uh,
Any day.
let this matter
This
appear
month.
on. দেখুন কবে আছে। Yes. আঠারো তারিখে সময় পাওয়া যাবে না শুক্রবারে, অন্য দিনে দেখুন আর কি। কি দুটোর সময় নাকি 3টে?
Before,
Huh?
before 16.
22/9/2000.
So let there be an interim order because trial court is
Yeah,
proceeding.
as the matter is sub judice before this court.
Your lordship, it will be extremely
Okay,
prejudicial.
okay.
It is on 16th. It may
Lordship,
be
she is
taken up.
restraining the
There are so
proceeding.
many matters. Okay,
Your lordship,
for few days, for 3 weeks, you will not suffer
She
anything.
will not prejudice CC.
everything they are taking, always they are taking adjournment.
Lordship, adjournment, I am.
I'm just,
It's already decided.
I am making it clear. As the matter is sub judice before this court,
High Court has already.
the
asked
parties
order.
may seek adjournment before the learned trial court, which may be considered.
Lordship, just one point. On the first order, while revisional application was admitted, your Lordship passed that similar liberty.
Yes.
But learned trial court rejected the adjournment, proceeded to the.
Okay, if the trial court rejects you come, I shall take it up.
Grateful, Lordship. Grateful.
Disposal is already.
Very well, I shall expeditiously dispose the matter, but come on the said day.
Before the trial court. Your
Very well, but let me decide this also expeditiously. So come ready on the next day.
Bow down, Lordship.
You seek adjournments on every date.
No, but please come ready on the next day.
For 2 years, they are just harassing me and my family, your lordship. They are harassed, and now it has been discharged. My husband has been discharged from all.
I shall hear out.
But they are filing endless number of cases, false cases, and now they are trying me to withdraw the case of the my client. On that point, the mediation failed.
আচ্ছা একটু একে পাঠিয়ে দিতে বলুন, আমি আসছি একটু 12টার সময়।
9 and 12.
Yes.
The last one, at around at 2 p.m.
Anyway, so 5 anyway. Let us see if it can be taken up in the first term. 2 p.m. this bench may not sit. That is why.
My lord, your lordship had fixed these matters at 2 p.m. on by way of my lord, the joint prayers of the parties. I was only praying, my lord, if these matters could be taken up at 2 p.m., my lord.
Anyway, if it is not taken up in the first term, definitely it will be taken up at 2 p.m.
My lord, Mr. Rupa Ghosh had also requested that he's in some difficulty as my lord, Mr. Shomabhu Ghosh. So therefore, your lordship,
I'll take it up at 2 p.m.
I'm so grateful, lordship.
Yes, call the list.
My lord, I am appearing for plaintiffs, my lord. This has come for certain typographical errors, my lord. I have indicated in pencil, my lord. I have pages, my lord, and in the first, lord, I have mentioned.
Page 7.
Mr. Ayan Dattu is appearing virtually, my lord. Page 3, my lord.
Your lordship, yes. Page 3, 7, 8. Yes, your lordship. The only changes are in the spellings of the names, your lordship.
Page 7.
My lord.
3, 7.
Then page 8, my lord.
Page 8.
8. Then 12.
Yes.
Then 14 and 18. Lastly, page 3.
And also page 19 and 20, my lord.
Yes, record an order. Learned advocate for the plaintiff is present. The matter is put up for necessary correction in order dated 31/7/2026. In page 3, first paragraph of the order, the name of Praveen Agarwal shall be recorded as Praveen Agarwal. In page 7, paragraph 13, instead of in page 7, paragraph 13, third line, instead of Sawar Lal Agarwal, it should be recorded as Sawar Mal Agarwal, SAWARMAL Agarwal. And thereafter, instead of PROVEN Agarwal, it shall be recorded as PWN Agarwal. It should be recorded as PRAVEN Agarwal. In page 8, paragraph 18, instead of PROVEN Agarwal, it shall be recorded as PRAVEN Agarwal. In paragraph 12,
page 12,
paragraph in page 12, in serial number 1 within bracket C, instead of Sagar Mal Agarwal, it should be Sawar Mal Agarwal, SAWARMAL Agarwal. Thereafter, in serial number 2, instead of Sagar Mal Agarwal, it shall be SAWARMAL Agarwal. Similarly, in serial number 3, instead of Sagar Mal Agarwal, it should in serial number 3, in place of Sagar Mal Agarwal, it shall be SAWAR Mal Agarwal. In page 14, instead of Exatica, EXATICA, it shall be recorded as EXOTICA. ঠিক আছে? Thereafter, instead of ASHAKA chambers, it shall be recorded as ASHOKA chambers. In page 18, second paragraph, instead of PROVIN, it shall be recorded as PRAVWN. Top. Hereafter, in paragraph 3, instead of Sawar Fal Agarwal, SAWARFAL Agarwal, it shall be Sawar Mal Agarwal, SAWARMALAGARWAL. Stop. Thereafter, instead of Praveen Kumar Agarwal, the word Kumar shall be deleted. Praveen Kumar Agarwal, instead of Praveen, PRAVWN, Kumar Agarwal, the word Kumar shall be deleted. Similarly, in page 19, Praveen Kumar Agarwal be recorded as Praveen Agarwal and Kumar be deleted. In page 20, instead of MONJIE Agarwal, it shall be MANJU Agarwal. Let the necessary rectification be made and the same be carried out within 2 weeks.
Your Lordship, possibly at the beginning of the order, Your Lordship had recorded the plaintiff is represented. Your Lordship, there are two plaintiffs in the suit.
Okay, plaintiffs is.
Grateful, Your Lordship.
Okay, I have fixed any date for submission of the report.
Yes, my lord.
When is the date fixed?
11th September.
Okay, so that this order is already communicated.
My lord.
The commissioner has taken steps also.
My lord.
Okay, so let that remain. Yes, call the next.
Sir, I am praying for extension of time to file the commissioner.
Okay, let me see the order. When is the date fixed?
It was fixed last expire on 27th of July.
27th?
July.
Of July. Yes, learned advocates for the parties and the learned commissioners, special officers are present.
Partition commissioners.
Learned partition commissioners are present. On the prayer of the learned advocates, the time to submit report by the learned commissioners stands extended till 25/9/2026.
Another thing, Lord, your lordships by your lordships order dated 17 July directed the department to correct the
Typographical mistakes.
Typographical mistakes. No, that mistake has not yet been corrected by the department.
Okay, the corrections to be made as per the last order, if not made, be carried out.
And lordship also direct the department to draw up the order, draw up and complete the order after correction be made.
The order be also drawn up in the meantime.
After making correction.
The order be also drawn up after making the correction.
My lord, only one injunction, my lord, parties be directed, my lord, to provide the copies of the judgments as well as my other papers, my lord.
No, they were corrected. No, after correction,
Let it be corrected.
My lord, I am appearing for the respondent contenders in the matter.
My lord, I appear for the petitioner, my lord. On the last occasion,
Lordship, I am
on the last occasion,
Lordship, I am appearing for the state.
Last occasion, Lordship had permitted us to file an affidavit to the, my lord, exception which was filed by RBI, and Ms. Chatterjee had pointed out that we had taken steps for clarification of the order in terms of what was observed by your lordship as to what would be the amount payable. Now, my lord, there's a subsequent order passed by the coordinate bench in terms whereof, my lord Justice Shubroto Talukdar has been appointed for the purpose of doing this exercise. My lord, this order is dated, my lord, 14th of August 2026, And this exercise is to be completed by 6th of October. So what I was praying is, if Lordship,
Immediately submitted in this matter.
So, my lord, I can't
yes,
your lordship's direction
Okay.
with deepest of respect. Kindly drop
Learned
the proceedings
advocates.
as far as Reserve Bank of
no,
India.
no. I am saying, my lord, keeps it after 6th of October. Let us come back with the adjudication, and then Lordship will hear the contempt petition.
Learned friend, finish. I'll indicate why the contempt proceeding since inception was wrong. I'll indicate. Let it come.
My lord, may I, if your lordship feels that the my lordship would be deferring the my lord contempt petition till the report is awaited, my lord, we are okay with it. But if your lordship is going to hear on the my lord contempt maintainability of the contempt petition, then I would request your lordship to keep it another day.
Not for submission, because the contempt, the inception of the contempt itself is wrong because of a coordinate bench's order, which was existing.
We have taken out a separate application in the of the contempt, my lord, to be added as a party petitioner in the contempt petition, my lord. Because we are also, my lord, an award holder, judgment holder, my lord.
Learned advocates for the petitioners and learned advocate for appearing for the state as well as learned advocate for the contemners are present. Learned advocate who represented the decree holder intends to file an application to implead himself as a party in this contempt application. Thus, necessary liberty is also granted. Liberty is granted. It is submitted by the learned advocates for the contemptor respondents that the contempt application is not maintainable in view of the subsequent orders passed by learned coordinate bench in this matter. Stop. It is further submitted that by order dated 14th August 2026, learned coordinate bench was pleased to appoint a mediator in the instant matter for the said proceedings. In the facts and circumstances, the maintainability of the contempt application as will be taken up for consideration along with its merits on the next date fixed.
Kindly keeps it after 6th of October.
Let this matter after 9th, okay, after 9th of October will be
Durga Puja.
okay, let this matter appear. No, when do you want?
It's fixed on 6th of October.
My lord keeps it on 9th of October. Lordship keeps it on 9th.
So I will be in some difficulty before the pujas. So your lordship will kindly make it.
Puja vacation is,
Yes.
we will start from 16th.
Yes.
So you'll be in difficulty for which date?
No. So far as 10th is concerned, I believe it's Mohalaya. I have Durga
10th is
Puja at my
Saturday.
place.
October
Yes.
10th is Saturday.
My lord, there
October
is
9th is Friday.
Friday I have difficulty because I have Durga Puja at my place, for which there will be puja also on the first day. So that's why if your lordship keeps it on the next Monday, then there won't be any difficulty. I will be here.
Matter appear on
That will be 12th, I think.
14
Yes.
10 2026 at 1 p.m.
Yes.
Very grateful. Very grateful.
Grateful.
My lord, only one correction,
Yes.
because my submission before lordship was that the inception of the contempt is incorrect. It is not maintainable because of the existing order of the coordinate bench. Your lordship had recorded that there is a subsequent order. Subsequent order means the order of 14th of August, which my learned friend had placed before lordship.
During after this order passed in writ application.
After the order which was
Passed in the writ
prior
application,
to
there are
the contempt
subsequent.
proceeding.
Subsequent order means the order against which the contempt is filed.
Very.
We'll address on the maintainability as well on the next
Yes.
date, my lord. Grateful.
Yes, record an order. Learned advocates for the parties are present. Today is fixed for orders. As the order could not be made ready, the matter stands adjourned till 18/9/2026 for orders.
In the meantime, I did file a notes of argument.
So you have not filed in the meantime. Okay, ঠিক আছে. Learned advocate for the defendant submits that she intends to file a written notes of argument. Let the said written notes of arguments be filed on 11/9/2026. Let this matter appear on. No, I am fixing the date আচ্ছা, anyway, let it be filed on 11/9/2000, তাহলে ওটাকে করবেন না 18 তারিখে for orders টাকে। তাহলে করুন যে today was fixed for orders, as the order was fixed for orders. As the order could not be made ready, the matter stands adjourned. Learned advocate for the defendant number 18 intends to file a written notes of argument. Such leave is granted. Said the said written notes may be filed by on or before 11/9/2026. Let this matter appear on 11/9/2026. Thereafter, I shall fix a date for orders.
Much obliged. I'm supposed to conclude today, but I will conclude. Note it down. No, note it down. But I will just, I said within 15-20 minutes, and I'll try to keep mine.
You'll give your reply.
Yes. And Lordship had made an order for written notes also. So, Lordship, may I?
I appear for defend numbers 4, 5, 6, 10, 13, 24, 28, 30, 31, and 34, the group of companies.
Anyway, it will
yes, my written notes is also ready. So if you yes. But after senior,
Maybe appreciate. Lordship will kindly accept our heartfelt.
Okay. Thank you very much.
Lordship, my association with the Lordship starts when city civil court. I had quite a few matters before my lord in that court. And thereafter,
but prior to that, long time ago, you were known. We were known.
Yes.
Prior to that.
Yes, exactly. As a judge, Lordship, I first appeared with city civil. Before that, of course, I knew my Lordship.
Anyway, so you have to give your reply on the point of law.
Lordship, I take my note and I'll finish it. Page 2 থেকে আরম্ভ করে one লেখনি কেন করে one নোটটা অথবা 2 থেকে আরম্ভ করে।
This is your written notes of arguments.
With my judgment. So
yes.
So logically, it takes a look.
Because
my first point is that this is a partition suit, which I had argued. It's a partition suit. In a partition suit, who are necessary parties? Who have a share? Who all the co-sharers? All the co-sharers are necessary parties. In a partition suit, one cannot implead who, according to the plaintiff, is not a co-sharer. In addition, parties can be impleaded who are claiming to be co-sharers. So that's my first point, my lord.
Anyway, you see, your submission on the facts of the case and the plaint itself, supported by decisions, is already there in the written notes of arguments. Today, reply means only with regard to certain points of law.
Yes, points of law. So I'm just summarizing my argument for them. So first point is, who are the necessary or proper parties in a partition suit?
Yes.
Only one. But I have the only thing I have added in my note, which I did not possibly place, was a passage from Mullah. I'm giving them a copy here and now, where who are necessary, who are the parties in a partition suit. Then I move on to, if it's a misjoinder of parties, now how did they try to make me a party? By saying that the plaintiff, that the defend numbers 1 and 2, since they are shareholders of companies, in which, some of which, the late Bhutoria, whose estate is being divided between the co-owners are, according to the note, which is also a fact I don't dispute, are the plaintiff and the defendant numbers 35, 36, 37. Widow, 2 sons and mother. Now they have made an averment that the defendant numbers 1 and 2 are given the paragraph reference also are necessary parties by virtue of them being shareholders of the 31, 32 companies, 3 to 34. Apart from a point that the company can't be partitioned, that's their main prayer. If I am impleaded, I am a necessary party, defendant numbers 1 and 2, by virtue of being shareholders of defendant numbers 3 to 34. Then look at their chart at 51 B to L. They themselves say in the plaint that there are other shareholders, well, 30 other shareholders. Then the suit fails for non-joinder of necessary party. What about the 30 other shareholders? In fact, there are other shareholders who have larger shareholdings than the defendant numbers 1 and 2. There are companies where defendant numbers 1 and 2 also don't even hold shares. There are other shareholders. That is their chart. This is part of the plaint. So either misjoinder or non-joinder. So order 1 rule 10, the suit goes. Order 1 rule 10, my first ground is order 1 rule 10. Misjoinder, non-joinder, and no cause of action against defendant numbers 1 and 2. And 3 to 34. I have nothing against the suit continuing between the 4 entities, or the 4 persons who, as per the plaint case, are the co-sharers of the estate of late Arun Bhutoria. Plaintiff and defendant numbers 35 to 37. Now, next point I go to in my plaint is, after those non-joined, order 1 rule 10, so my name is liable to be struck off because there is no cause of action. Next is the praise E2 ended is. এত খারাপ নোট লিখেছে, এত খারাপ প্রেজেন্টেশন করেছে, they couldn't manage to make it as bad as possible on my note. Praise E, F, and G are for partition, main relief. Partition of a company. Just because, according to the plaintiff, her late husband had some shares in these companies. That too, as per their chart, that is not so, but let's assume that the late Arun Bhutoria had shares in these companies. How can you partition the company or company's asset? That is their specific prayer. I have cited the 2 judgments, Bachagazdar and the Delhi High Court, where it says so many words, cannot be a partition of a company. Company, even if it's 100% shareholder, is a separate entity. I had also relied upon, apart from Bachagazdar, I had also relied upon that Deepak Ramesh Kumar Bhagchandka, then Amrit Lal, Bombay High Court, Delhi High Court, Supreme Court, or Calcutta High Court. Narendra Burlia. I have relied upon these 3 judgments. Then, my lord, my next point I go on to is paragraphs after paragraphs on mismanagement of the affairs of the company. And reliefs claimed on that basis. I have quoted them in my note. At pages 10, 11, 12, I have quoted those paragraphs which I had placed, 10 to 14. And they claim reliefs also on that basis. Mismanagement, oppression of the company. Specific pleading. 430 of the companies. That part. I am not asking for partial rejection of the plaint. I'm being very clear, my lord. I'm not asking for. I am saying strike out the names of these entities against whom you have no cause of action. Strike out the order 1 rule 10. Like the way our division bench in Lakshmi Nivas Mittal, Lakshmi Nivas Mittal had done, that is our division bench, Shonjib bench, where Supreme Court had done in Church of Christ. Strike off the names of the and order 1 rule 10.
That is there. Order 1 rule 10, court at any stage can direct that.
So if you don't have a cause of action.
Yes. That's a different issue. Order 7 rule 11.
Now, lordship, next point is 430 is done. Next I go into that there is a averment that the defendant numbers 1 and 2 are holding all the properties, their personal properties, as trustees for Arun Bhutoria. Then again, it's a bar, my lord. Sections 5 and 6 of the Indian
So
Trust
that you have
Act.
relied upon decisions.
Upon decisions, firstly, there is no who settled the trust, who are the beneficiaries, when was the trust settled, nothing mentioned, just by one averment. Where is the trust deed? Upon decisions also, Lordship. Then, Lordship, then Lordship kindly comes to the judgments they have cited. Lordship, kindly come to page 17 of the plate. Sorry, page 17 of my note, where I've distinguished the three judgments
Page
cited.
17, yes.
The first judgment is the Santosh Kumar Agarwal's judgment of the division bench. If you kindly know, this is that there was an application for partial rejection of plaint.
Yes, that is the main thing to be done in the reply. You distinguish the
So,
judgments
Lordship
and
kindly takes a look at the judgment of Santosh Kumar Agarwal. Now I copy that. Santosh Kumar Agarwal, that is the cited by them, paragraphs 38 to 42. It was a suit for partial rejection of the plaint. Sorry, application for partial rejection of the plaint. In that context, the division bench held that there cannot be a partial rejection of the plaint. Lordship, they must say,
can you please read out that relevant paragraph?
I am reading. Santosh Kumar, yes. Paragraphs 38, 41. The heading, that chapter which is on paragraph 38 onwards, the caption is partial rejection or return of plaint. So on that basis, we find from the relief sought in the plaint that the argument as to the NCLT having jurisdiction applies only to certain consequential reliefs sought in the suit in respect of alleged mismanagement of the funds. So, even if the said reliefs are held to be barred at the final hearing, the primary relief of declaration and partition cannot be held to fall.
So that was also a suit for partition.
Partition and
so
for
unlike like this suit.
Yes. And there the application was partially reject the plaint, those oppression mismanagement. I am not saying that. I am saying can I see my prayers?
That you are not a necessary party.
Right.
So it should be dismissed as the misjoinder of parties.
Yes. Misjoinder of parties or parties against whom there is no cause of action. If you kindly takes a look at this judgment, page 11 of this judgment. The whole case was on order
yes, partial, yes.
Order 1 route was not even discussed. And I had given the judgment the striking of the names of defendants. And Order 1, Rule 10, Church of Christ, 2007, 8 Supreme, 12 Supreme Court. Our division bench, Lakshmi Nivas Mittal.
This is a reported judgment, this FM 8543.
Reported? Oh. Maybe SCC online, I don't think it's journal. The whole case, Order 1 rooted was not, there was no application for striking of the name. If someone asked for partial rejection, said you continue with your suit as it is. And Lordship, the language used in section 430 is not to entertain. So that's on a different point. That's on the oppression mismanagement. But I'm saying you strike off the name. So then, if I hold 10 shares in ITC, so if my issues have a partition suit, my children have a partition suit, will ITC be a party? Because ITC has 10 shares, I have 10 shares in ITC, I have 20 shares in Reliance, I have 30 shares in, they'll be all parties. Because some shares are being partitioned this shares. So I'm not asking for any partial rejection of plain strike of the name. And that's paragraph
According
41.
to you, this judgment does not apply to the facts of the case. Yes.
There they wanted a partial rejection of that part of the plaint which pertained to mismanagement and oppression. Vishwanath Bhundabarkar. Move ahead. Vishwanath. I am supposed to remember that. Good. Then the Bishwanath Bonic's case 22-7 SCC. I don't know why they have cited. There it's a proposition, also not a striking of case. Bishwanath Bonic's judgment. There it was a case that the plaint has to be read as a whole. You know, that's what I am stressing. I want the plaint to be read as a whole and see what is the cause of action against the 31 companies and also the defendant numbers 1 and 2, who are admittedly not co-sharers of the party of the suit. Then there is also, Lordship, there are the 2 judgments cited by them. So while I have distinguished these judgments at in the last page of my note, none of them are striking of case. And kindly see my press C, the names of defendant numbers 1 to 34 be deleted from the array of parties. So order 1 rule 10, I am saying. That is really all my notes I have filed.
Anyway, your notes and this written arguments all are there.
I'm very
so I believe all have submitted their written notes
I
of
don't
argument.
know about others.
But I appear for, as I've indicated, the group of companies 4, 5, 6, 10, 13, 24, 28, 30, 31, and 34. My written notes is also ready, if I may, my learned colleague, submit the written notes,
Please submit it.
Kindly takes it on record.
Yes, record. Okay. I thank all of you for your cooperation.
I'm so grateful to your lordship, and we are really elated for hearing the news of the notification.
Okay, thanks.
Defendant number 3. For defendant number 3, I'm filing that.
Yes. Learned advocates for the parties are present. Learned advocates appearing for the parties have filed their written notes of arguments. Let the same be kept with the record. Hearing is concluded. Let this matter appear for judgment on 25/9/2026.
I'm very deeply obliged for the patient hearing. Very deep.
Okay. Thank all of you.
Grateful.
এটা রেখে দিন। এটা এর মধ্যে যেন ঠিক থাকে বা এটা স্টিচ করে দেবেন এর মধ্যে, নইলে এটা আবার ইয়ে হয়ে যাবে। 25 নয় তো এটা ইয়ে থাকলো।
Well, in this matter, a report has been filed by the collector.
Well, if your lordship recollects that,
We are
finally, my lord, finally, at
Fine.
last, it's been a very, very long time.
report.
Yes.
Except
No. That I cannot permit you. It is between
Sir,
the
Lordship
state authority and this court. I cannot permit you that.
Lordship,
If you see, if the collector was asked to assess the stamp duty and thereafter they were directed to file the report.
Lordship.
You see, if you think that the collector's report is not sufficient, there is an appellate authority. But I can't grant you any leave to challenge it here. Okay.
The civil suit here first.
No. That-
Mr.
Whatever
Lord.
you see, I'll grant you that liberty. Whoever is aggrieved to go before that appellate authority. This court is not the court to go into that. Yes, learned advocates for the
May I
parties are
just,
present.
my lordship will kindly see, my lord.
Yes.
Well, kindly, this liberty, what my learned friend is saying, exception, in a civil law, it's not permissible. Your lordship has sent the document, regularized, stamp duty, pay.
এই আগের দিনের অর্ডারটা দেখি
24th of July. May I hand over, my lord?
Learned advocates for the parties are present. In terms of order dated 25th July 2026, there was a direction. Okay. It was observed that there was an observation that the stamp duty was already paid and the registrar original site was directed to send the MOU to the collector of stamp duty. I think 24th July the matter was taken up.
Yes. I give you lordship the 24th
For
July order.
making necessary endorsement on the same and issue certificate in this regard. Regarding payment of stamp duty. So
this has been done, my lord.
Necessary and issue certificate in this regard regarding payment of stamp duty. The MOU was sent. There was a direction that MOU be sent to by the register original site to the collector of stamp duty, register of assurance, Kolkata, for making necessary endorsement on the same and issue certificate in this regard regarding payment of stamp duty. Stop. Thereafter, today was fixed for necessary report. It appears that by order dated 10/8/2026, the collector of Kolkata communicated to the assistant registered writ and execution department OS that the original MOU was received on 30th July 2026. Stop. The process of certification on the original document with signature of the collector of Kolkata stamp and revenue has been completed on 4/8/2026 after realization of the assessed stamp value. Thus, the original MOU is being returned. In the facts and circumstances, this court is of the view that the order for assessing the stamp duty and paying the same has been complied with. Stop. Although learned counsel for the appearing for the defendant submits that he intends to take an exception to the report filed by the collector, this court is of the view that this jurisdiction cannot be exercised by this court as to whether the stamp duty is assessed by the collector properly or not. There is another appellate forum under the Stamp Act, an appellate forum under the Stamp Act, and parties can take necessary steps under the said law. Thus, the prayer to take exceptions before this court is refused. Let this matter appear on 18/9/2026
for continuation of arguments.
For further arguments.
For further.
By the defendant.
Right. So, my lord, the defendant was addressing your lordship.
Yes, they will continue.
Well,
Argument, evidence over.
yeah,
Arguments. This is a part-heard matter. Arguments. You have argued the matter. So resume your arguments.
But I'm assisting Mr. Bose, just to make my presence felt.
Okay, record your presence.
Will appear for the petition in this matter, my lord. By order dated 17th of July, your lordship had referred this matter to mediation, my lord. Mediation is still going on, my lord. The next sitting is fixed on 29th of August.
Mediation before Justice Talukdar.
Honorable Justice Indira Banerjee.
Oh, Justice Indira Banerjee.
Yes, my lord.
So mediation is continuing.
Yes, my lord. The next
So
date
let
is on
it be after
29th.
3 weeks. When is the next date?
29th, my lord. Next Saturday.
Kindly extend 4 weeks, after 4 weeks.
Kindly extend it for
Learned
next 4
advocates
weeks,
for the parties are present. As the mediation proceedings is continuing, let this matter appear for report of the learned mediator on 25/9/2026.
25/9. 25/9 takes it to 5 weeks, my lord. 18 September is perhaps 4 weeks.
Okay, 18/9/2026.
And my lord, my interim order is expiring on 28th of August, my lord.
The interim order passed earlier stands extended for a period of 5 weeks.
6 weeks, my lord.
6 weeks or till further orders, whichever is earlier.
I'm grateful.
Anyway, mediation is continuing.
Yes.
They will not take any steps.
Yes, yes. 6 weeks, your lordship. So grateful, your lordship.
Lordship, I be permitted to provide my judge's brief, Lordship, in this matter.
Yes, GA3 is to be disposed of.
Is already disposed of, Lordship. But this thing.
In master.
The appearance of all the parties is complete. The service of summons upon all the parties.
Is a complete, Lordship.
So, but they have not, the defendants have not appeared.
Not appeared, Lordship. I have got the letter from the department, Lordship. They filed their it's just to them. This is the department's letter.
Who is appearing for the defendant?
Khaitan and Company, Lordship.
Learned advocate for the plaintiff is present. Let the judge's brief of documents filed be kept with the record. Let this matter appear for hearing on 25/9/2026. The learned advocate for the, yes, they have entered appearance.
Yes, Lord.
But so far written statement is concerned, it is defective.
Defective.
Learned advocate for the defendant be intimated. Okay, so intimate them. 25/9.
25th of September.
May it please your lordship, my lord, I appear on behalf of the joint administrators. This is a matter in which, my lord, a suit has been filed by my learned friend's client against Chatterjee Pork. My lord, the joint administrators have, pursuant to an order passed by this honorable court, directed to take possession of all the assets of Binoy Chatterjee. My lord, the suit was filed subsequent to the joint administrators having had come to the picture. But this suit, my lord, does not in any way mention any of the joint administrators. They are not made parties. An ex-party decree has been passed, my lord, with regard to...
So this is GA application, is your application?
My application for setting aside the ex-party decree.
So that is to be heard out.
Yes, my lord.
So that is to be heard out on merits.
Yes, my lord. That is to be heard out on merits. Only one difficulty that, my lord, we are facing is, since 2009, there has been various orders passed by this honorable court directing the plaintiff to serve a copy of the plaint. I understand the department has recently said that the plaint is not traceable. So, my lord, it has to be reconstructed. I'll tell your lordship why. The decree, if your lordship kindly comes, my lord, this is a part of the execution petition that has been filed by them. If your lordship kindly comes to the ex parte decree, which is at page 26 of GA number 2 of 2024. Application.
26, yes.
Yes, that's my application.
Yes.
My lord, your lordship will kindly come to page 26.
Yes.
That is the ex parte decree. My lord, I'll not trouble your lordship with the entire decree as such. Page 27, if your lordship kindly comes. More towards the latter portion, my lord. If your lordship kindly comes there, the Registrar High Court original side be directed to execute, my lord, more towards, if I may just indicate, my lord, it's here, this portion of the page. Your
Yes,
lordship, I got-
Register High Court
Yes, ma'am.
original site.
Yes, ma'am. The Registrar High Court original side be directed to execute such deeds of conveyance as mentioned above in favor of the plaintiff and or her nominees, and get the said deeds of conveyance duly registered with the Register of Assurance and or other appropriate registration authorities for and on behalf of the defendant for a decree for rupees 75 lakhs only as mentioned in paragraph 68 of the plaint. My lord, my humble submission would be, until and unless, my lord, the plaint is being served on us, my lord, we would not know as to what has been the scope of the plaint filed by the plaintiff on the basis of which the decree has been passed. My lord, we have specific prayers. Our application is based mainly, my lord, on the fact that we were not served with the writ of summons because the address of the registered office of Chatterjee Pork is different to that which has been shown. Number
Were you a party in the suit?
I was not a party.
Not a necessary
I am
party.
that I am a necessary party. I'll prove because my lord, if your lordship kindly comes to a list of dates, has my lord been handed over a list of dates? My lord, may I hand over a list of dates?
Before my learned senior, my lord, shifts to necessary party, may I just meet with my learned senior's point with respect to the plaint?
So the affidavits are all exchanged in this application. So I have to hear out this application.
Yes, your lordship.
So what is necessary or not, I shall consider.
Yes. That your lordship will.
I'm sorry.
Yes.
May not the submission, may I just meet with respect to the availability of the plaint? There was a affidavit called for by me to produce all documents with respect to the plaint, the specific undertaking whether I have the plaint or not. On affidavit, what I have said, I do not. The department was requested to. The plaint is not with the department. And what my learned senior is saying that the decree is based on paragraph 60.
A portion of the decree, not the entire.
I'm sorry. A portion of the decree is based on a specific paragraph of the plaint. The reasonings are there in the decree.
Maybe so.
1. 2. As on date, my lord cannot go behind the decree. My lord can see whether the decree is executable.
Whether the decree is obtained by fraud or not. That is the main thing.
That
is
their given.
Yes. But for that, they have to show that this decree has been obtained by fraud on the face of it. But I will show that a part of this decree has already been enforced by my lord's predecessor in chair. The portion that was supposed to be registered in my favor, the registrar has executed the deed of conveyance.
With regard to that, no appeal is preferred.
No, they attempted. I shall show those also. There was a section 47 application filed, rejected on its merits on these points itself.
By the joint administrators.
I mean, same point.
By the joint administrators.
The person who's filing is irrelevant. The point
that is the most important thing.
My lord will take the point. I shall show those points.
That is the most important. I'll tell him after
because it is their application. Let them submit.
In that, may I just say this? In the previous 47 application, the joint administrator appeared. Not only
are these reflected in your affidavit in opposition?
Yes, everything is reflected.
Whatever your learned senior friend is saying?
Yes.
So I'll consider that.
Very well.
Thereafter I shall see.
Your lordship will consider that, but only one thing, my lord. If your lordship feels that your lordship will proceed with the matter without the plaint, my lord, I cannot quite say anything.
To hear this application.
Yes.
Whatever is necessary, I shall consider.
Yes. My lord, may I just see show your lordship the order that your lordship was pleased to pass on the 5th of August. There has been another order subsequent to that, but I'll come to that, my lord. I'm just handing over my copy, 5th of August.
Application
5th of August.
19th, 2025. Was there any earlier report of the department that they cannot put up the plaint?
Yes.
Anyway, that I shall consider because this direction is there.
With respect, my lord, the plaint has to be reconstructed then, with deepest of respect.
On multiple occasions, I do not understand why.
Because you see, you don't have a copy of the plaint. Yes. I think the decree holder, the judgment debtors who have not appeared,
ventilated their grievances, absolved. Now not appearing any further.
Only thing is this, to some extent, this is an Order 21, Rule 101 application. You see, to some extent, this one.
To some extent, yes.
Order 21, Rule 101.
Subject to correction, Lord.
Because their main contention is the decree is obtained by fraud.
Yes, but
so
who make this contention?
Yes.
They are merely a custodian.
Achha.
That is exactly my case. Who am I? I will answer that to my lord. That
They are
is exactly what
merely
has
a
happened.
custodian who were obligated by orders of court, and I shall show to what extent, to hold on to sums and for disbursement.
Oh, you see, if upon considering the other records, other orders,
Yes.
if I find that the plaint is not necessary, I shall proceed with the matter.
Yes, very well. Then
Okay, let me see the report.
yes.
This is suit of 97.
Yes, my lord. And show, my lord, how the decree has been passed. Before whom the decree has been passed.
Suit of 97, decree of 2000.
And joint receivers appointed, joint administrators appointed in 83.
No, I'm not saying that joint administrators were not appointed at the time the decree was
How
passed.
can you?
I
It's a matter
cannot.
of record.
I cannot. That's why I'm not saying that, sir.
Okay. So continue on the next day.
My lord,
Continue
then
your
in that
submission.
event, your lordship.
I'll direct the department to take
I'll
steps.
report.
In the meantime, this hearing will continue.
Yes, my lord. I was,
Subject to my
yes, I was, my lord, your lordship will recall, my lord, Mr. Deb, Mr. Sudip Deb, who has now been elevated, was there.
Yes,
So I
yes.
was only praying if your lordship gives me 2 weeks' time. I also have to get, I've just been briefed.
May I just say this, subject to the test that my lord puts me through, and of course what my learned senior says. Existence of the plaint and importance of the plaint is a part of their application. My lord is calling for the report, I do not stand in the way. In the event my lord feels, after hearing my learned senior and me, my lord, that a plaint was required, and in the absence, the decree is a nullity. My lord will decide that as part of the application, because there are reports galore and declarations by me and orders passed by this
That
court.
I shall consider, you
Yes.
see.
No,
That-
my
there's
lord,
no point
one
having-
of my point, I understand why my learned friend is, if I may use the phrase, wants to hide the plaint. I can make out very well. My lord, if that is a point in my petition, my lord, without the plaint, from the basis of the execution application filed by my client, I've been able to find out as to what fraud has been committed upon me, means the joint administrators. If, my lord, the plaint surfaces, then, my lord, I've reserved my right to make some additional point with regard to
And
the fraud.
if the court is satisfied that the decree was obtained by fraud, then court is empowered to set aside that.
I'm obliged. My
I
lord,
will
some
also record
additional.
my undertaking
I
that
would
the
be-
plaint is not with me.
My lord,
That I shall require.
Kindly record.
reconstruction is always
Learned
can always
advocates
be
for
done.
the parties are present. Mr. Ghosh submits but could not conclude his submissions. Stop. Although there was a direction on 5th August 2025 upon the department to put up the plaint of the suit, a report is submitted to that effect dated 14th August 2025 that the said plaint could not be traced out and time is sought for to trace out the said plaint. Stop. Said plaint. In the facts and circumstances, the department is granted another opportunity to trace out the said plaint on or before 25/9/2026. Stop. It is, however, made clear that the hearing of this matter will not be adjourned due to non-availability of the plaint, and the hearing of the matter shall proceed. At this stage. Let this matter appear on 25/9/2026 at 2 p.m.
As your lord, 25/9.
Let a copy of this order be sent to the register original site for necessary steps. Achha, regarding the joint administrator, is he paid monthly remuneration or one time?
In a different suit, there is
Monthly, I understand monthly remuneration.
So he is receiving monthly remuneration.
That they are.
That's in a different suit. I'm sure my learned seniors are taking
So
care
that
of
is
different suit, but in the same premises. Properties are regarding the same
anyway.
premises.
So this suit is not the subject matter before this court.
No.
Yes.
Suit
this is
where
very
he is.
much.
No, this suit.
Yes, I'll tell you what happened. This suit pertains to agreements for sale with regard to certain flats, situated in Chatterjee International, over which the joint administrators have been appointed way back in 1983. So, my lord, joint administrators were given the power in another suit with regard to the same property. Subsequently, my lord, I put a question to myself. If I am the joint administrator of property A, if any prayer is being made with regard to that property subsequently, am I not to be added in as a party being an officer of court? That is the question. My lord, in 1997 suit has been filed. 83 joint administrators appointed over the entire building, directed to take possession of the building and also to sell properties for the purpose of disbursing the money to the depositors from whom the original loaner had taken money. Having had knowledge of all this from 1983 to 1990.
Anyway, so in that event, I shall hear out the matter.
Yes, your lordship
I can
will.
do one thing also. You see, if both of you are agreeable, I can send this matter to mediation also.
No, my lord, I don't think that will be of
Lord,
any.
my decree, they are saying fraud. I'm sorry, my lord, I'm saying this of my cup.
Because let the matter be resolved.
My lord, your lordship, kindly hear the matter.
I'm sure my learned senior will also not join issues. Mediation will not be an appropriate remedy. Lord,
And the properties have already been sold, I understand.
Yes.
After having been taken by them, all properties sold.
14.
Well, this amount of money should be going to the depositors.
I asked myself
bring
this
to your
question:
lordship
have they brought a
notice.
suit for delivery upon cancellation of those instruments? The answer would be no. my lord.
Anyway, if I'm
On
saying,
the one hand, they've accepted.
Are the purchasers before this court?
the purchasers are not before the court. My lord,
Exactly.
the purchasers are not before the court. The person who are purchasers have not been made parties also. Only one purchaser has
The
been made a
suit
party.
is now this property is the joint administrator is looking after the property.
Yes, my lord.
So who is occupying the properties? At
These
present-
particular flats.
Yes.
These particular flats have been sold to third parties.
So they are in occupation of the property.
Must be either they are
Those
in
are not
occupation.
issues before my lord. I shall
So
indicate.
how many flats?
14.
How many total number of flats?
14 with regard to this.
पूरा building is at
Oh, on the whole building, man.
Upwards of 150.
কত বলো?
255.
Nearly
So let
255.
me, if some report is necessary as to who are the occupants of those
Well,
flats.
that's with regard to some other suit, my lord.
Those are all pending. my lord.
Well, here, the subject matter is limited to only the flats over which they have already filed the suit.
Now
Only
regarding
those flats.
now, who are in occupation of those flats?
These flats, the ones which are, my lord, for
Which is
that,
the subject matter of the suit property?
then we,
My lord,
they
the
will be able
flats
to
that
say
have been
because they have
sold
sold it.
have been sold by the seal and signature. Deed of conveyance have been registered by them.
Then
Yes.
let me obtain a report with regard to who is
Those are
got in
not-
occupation.
My lord, may I am sorry.
No,
my lord.
you see, you want execution of the decrees of the suit property.
No. I am only for money. Suit property has been executed, registered, gone. The
Money
registered
from whom?
is
Money from the judgment.
administrators.
Money as per paragraph
Because
68.
orders
That
have
is
been
exactly
my
what
lord,
I had brought to your
very well,
lordship's
my lord. May I
notice.
then may I kindly my lord takes the opposition page 46. This will be
No, I
clear.
shall take, you see, this picture has to be
The
before
picture
me.
will be extremely clear. My lord. Kindly takes page
Now the
46.
question is, so far the suit property is concerned, no question, no dispute with regard to possession.
Neither are they raising.
Now only thing is this,
I am raising.
only now you see, none of the purchasers or the judgment debtors have come. Okay, neither the judgment debtors nor the purchasers have come.
Never come.
Only there is a decree with regard to payment of money. What the decree was against? The judgment debtors.
My lord, if I may, if it's not
Yes, yes, yes.
specific performance suit, there has been a decree directing specific performance with regard to the deed of conveyance being made with regard to certain flats in the property. In addition to that, I also fail, my lord. In addition to a specific performance, decree for specific performance, there's also been a decree for certain amount of money, some 68 lakhs.
Damages
Oh, 75 lakhs.
75 lakhs, 10,000.
75 lakhs.
for damages.
I do not know that. That is as
No, that is the decree. Decree will speak for itself.
that is exactly what the decree is saying, my lord. If
Judgment and decree.
as per paragraph 68 of the plain.
Now the question is, you see,
That is a submission, my lord.
That is what, my lord, that is exactly what I was saying.
clear-
Apart from the points of fraud, I would also like to know why I have been made to pay this 70 lakhs as per paragraph 68 of the, please, this is not done.
Right, sir.
Please, some
Right, sir.
etiquette
Right,
should
sir.
be
Right.
maintained. Paragraph 68 of the plaint. What is paragraph 68 of the plaint? I do not know. I have to pay that amount of money. That is exactly what I have brought to your lordship's notice. Your lordship will kindly come to that decree once. As mentioned in paragraph 68 of the plaint. I do not know that I have to make this payment of money. How much? Why? What is the case made out in paragraph 68? That is the reason why.
Unless you see the court gets the picture from other orders, okay, the entire orders or other applications, it will be difficult to decide with regard to that, to execute the decree. You see, unless the decree is before the court, okay, the court will find it difficult to execute the decree.
Before the court, my lord. Decrees before the court, my lord, with deepest of respect.
That paragraph 78.
Decree does not specify.
That paragraph 78.
Yes, as to why 75 lakhs has to be paid. As mentioned in paragraph 68. What is paragraph 68? I do not know. Neither does my learned friend.
From other documents, it has to be inferred.
Orders.
Other
Orders of court.
Other orders, or if there are other relevant documents.
Orders of court. I shall not take my lord to any document.
What is that paragraph? Okay.
Yes.
We all.
Yes.
Are you, your learned friend? All are in. Yes. All are in the dark with regard to para 78.
Lord,
68.
68.
Para 68 of the plaint.
68 will have no relevance, and I shall show why. From orders of court, not from any other document. From orders of
you see, some money has to be paid from that paragraph, or relying upon that paragraph.
That is not the entire picture, Milord. Milord will hear me out whenever Milord calls upon me.
Anyway, you conclude on the next day.
I'll conclude means I'll have to comments.
Comments and conclude.
You have already comments to show me why this is not maintainable without you being added a part.
That I've been.
Also, Milord, to meet the.
If you can show that the suit is not maintainable, this degree could not have been obtained without you being made a party, then they don't have a case.
Yes, I'm obliged. So your lordship is currently keeping it for September.
Yes, the matter
25 September.
25/9.
Lord,
Let
may I
them
just-
trace out the plaint also,
Lord, may I-
and let your learned friend trace out some other documents if it is available.
Or, Milord, I was given an undertaking to file all documents in the form of compilation. My lord's record also has that. Every, तीन बार. Whatever. No, of course, আমি আপনাকে আরেকবার দেবো, sir.
So no question of any possession, only this monetary relief.
I will be, my lord. My prayer would be that the ex parte decree would have.
Oh, that you did not file any case. That you did not file order 9 rule 13.
That is my case.
No, order 9 rule 13. Where have you filed? Application to set aside ex parte decree.
On the basis of fraud. On the basis of fraud.
Okay. This application is there. Oh, you see, order 9 rule 30 ex parte decree is available to the parties.
Was available.
I have not been made a party.
Yes.
Someone else who was interested.
So that is why this section 47.
Yes, my lord. That is the reason why I have come up with this application for setting aside the entire decree. I'll tell you all, lordship, I'll satisfy.
Because you see, if you either you succeed or your learned friend succeed. If you succeed, then the question, then first of all, this money goes, no question.
Or not
Now,
only
what
the
happens
money.
with regard to, no, if I want to set aside the ex parte decree, I have to give notice to all the purchasers.
Yes, your lordship would.
Immediately.
If that would be required, your lordship would. Your lordship has.
Fascinating thing would be, Milord will also have to give notice to administrators who's executed the conveyance.
Yes.
On the basis of his.
All have to be granted a notice.
Who my learned senior is representing. It's a very unfortunate situation that the facts are being portrayed in this way, Milord. Milord will hear me on that day. I shall make it crystal clear from orders of court.
Because
that
you
these
see,
are not
the moment I set aside ex parte decree, all these purchasers have to be brought in the picture.
And I assure Milord will stop by principles of res judicata, because these are already agitated and decided.
Let's
division bench.
Anyway,
Let's see on the next.
My lord,
Yeah,
may I
right.
get back? May I get
Yes,
back
yes,
those
yes,
orders
please.
and
Please
the
take
list of dates for the moment?
Lordship, may I to leave to
Yes.
item number 10 in appellate side. Your lordship kind enough to fix the matter on 16, but your lordship did not extend the interim order, my lord.
So come at 2 p.m. intimate the other side.
Yes, my other side.
You, appellate side officers are not here. Acha, kya appellate side? Extension.
Interim order ছিল মা।
কে আছে নিয়েছে কি অর্ডারটা? হ্যাঁ? Okay. কিন্তু কেউ নেই না, no officers are here from the appellate side. Okay, come at 2 p.m. একটু খবর দিয়ে দেবেন।
Obliged, my lord. Obliged.
Yes, what is the item number?
10, my lord. Item number 10.
Item 10.
10.
Yes, record an order. আচ্ছা, আপনি অর্ডারটা লিখেছিলেন কি আছে বলুন তো?
For the petitioner is present, the argument petitioner is completed. However, respondents
complete.
are granted.
Is complete in a
Is
complete.
complete. However, respondents are granted to liberty to submit their opposition along with written notice of argument. The next is this matter appear on public at 2 p.m.
16-26 The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier. All good.
Lord, you've taken out an application which is GA 16. 17, I'm sorry, my lord.
GA 17.
Yes. Should kindly take up the application. The lordship will kindly recall that there was a letters of administration which was granted, which your lordship was pleased to revoke. My learned senior friend came, Mr. Ghosh, and indicated that he has filed an application seeking recalling of that order. Based on that, my lord, your lordship was pleased to direct the parties to
এই এটা দেখি মাস্টার সামান্সটা Yes.
Now, on the application of Mr. Ghosh, which is GA 15, on 19th, on 10th April 26, your lordship was pleased to direct the parties not to take any steps with regards to, my lord, the properties of the estate. Whether, my lord, it is belonging to the deceased Rajmata Durgesh Kumari Devi, or whether it is belonging to Bhuvaneshwari Prasad, whose will is there, which is also under probate. Lordship directed us not to take any steps. This order has been continued.
Lord, I am agreeing to the, what are you seeking?
I am seeking that no effect be given to the power of attorney which has been.
Lord, I am agreeing to that. Because that was the order.
Yes.
Power of attorney for?
Not to be given effect to the power of attorney. My lord, there was some miscommunication. When your lordship has given an order that both parties should maintain status quo in respect of the properties, my lord, that has to be, my lord, given.
They have entered into a power of attorney subsequent to the order.
Although a power of attorney doesn't mean actual
because
alienation.
They have given right to alienate.
No.
That's
Power of attorney, you see,
very well.
if the parties are to maintain status quo,
That's right.
whether parties by themselves or through their agents,
yes,
ultimately have to maintain
Right,
status
I am
quo.
saying kindly record my undertaking that I will not, either me or my power of
Or through
attorney
your
holder,
authorized agent.
no, will not do anything in respect thereof. In
Yes,
respect
record an order. Learned advocates for the parties are present. When is the matter fixed? Earlier it was fixed?
Yes, my lord, it was fixed today.
Okay. Learned advocates for the parties are present. The affidavits are complete.
No, it's moving for the first time. But there's no question of using an affidavit in this because I cannot do what your lordship has asked me not to do. This was done, my lord, under.
Let this
I
matter
think some miscommunication.
appear on 11/9/2026. The interim order of passed earlier shall continue.
But there's no interim order on this application.
No interim order in this.
Interim order passed in GA 15
In GA 15
of 2026.
It's been made, my lord, till disposal of the application GA 15.
Yes.
I am saying, my lord.
15 shall continue.
Yes.
It is hereby clarified that the parties shall not alienate themselves or through their agents any portion of the suit property.
Of the estate.
Of the estate.
My lord.
Of the testator.
By the
Of the estate of the testator.
Of the estate of the testator, my lord, by way of the power of attorney.
Anyway, either
which way?
themselves or by through their authorized
In
agents.
any which way.
Power of attorney means through their authorized agents.
তোমার কিন্তু undertaking দেয়া আছে মক্কাকে বুঝতে
I'm
হবে।
only praying, my lord, there should be an order in terms of prayer A and B.
Lord, I'm saying there's no order is required to be passed. I'm offering my
Shall
undertaking.
continue till disposal of the application GA 17 of 2026. It is hereby clarified that the parties shall not alienate any portion of the properties of the estate of the testator, either
Testator.
estate of
The estate, the deceased.
the deceased, of the deceased either personally or through their authorized agents
In any which way. Your lordship adds that also.
by any means.
Yes.
And in my lord, particularly by way of the power of attorney of 6.
My lord, I am saying it will
Agent
not
mean
be
what?
done.
Any
That order, because thereafter this.
If it is done,
Only-
my learned friend knows
again
what
you move
to
an
do.
application.
I think what is the difficulty? Tomorrow, my lord, my learned friend is here, but his client might say that I didn't give this undertaking.
That is why I
But
passed
you
an order.
kindly, my lord,
Authorized agent and by
operation
and by their power of attorney
But-
holder.
Yes.
power of attorney dated 6 June 20.
No, and their power of attorney holder.
Kindly put, if it's a commences, my lord, kindly
No,
put
no,
in the
power of
date 6
attorney
June
holder
20.
means any.
Protect
That is
it.
there. Any power of attorney holder.
There will be some other power of attorney.
Any power of attorney holder.
Any which way, I suppose, encompasses everything.
And
I think counsels will advise their clients accordingly.
Yes, yes.
They will not. They will find any way to escape.
As well as there's a deed of assignment.
And I believe the last time I checked, there is the contempt jurisdiction is there in this court.
That is what they want. I'll keep
That's
coming
right.
back. Well, the only thing is, well, there's also an assignment deed that also has to be stated.
I am saying that nothing will be done. If assignment deed is already executed by me in favor of anybody trying to transfer, then my lord, then it has to be recalled and my lord set aside.
Anyway, clarification is
That
given.
my lord, kindly allow me to file an affidavit to that. But
Yes,
nothing.
but no effect be given to any.
How
transaction.
can we do it
It is there.
if it's a registered document?
No transfer either by themselves
Yes,
and
or through their
authorized agent and by their power of attorney.
Window assignees, my lord.
No, what is that assignment? That is by any means. That is also a transfer.
Then you should have
Yes.
given notice to the
That is
assignee.
also a transfer.
Of course, my lord.
Give notice to the assignee.
Anyway,
Assign,
that is
it's given
whatever
because
is.
it's him.
So
He is the assignee.
assignor or assignee.
He is the assignee as well.
But then what should I? If I then I'm bound. Then I'm bound by the order.
From the assignment.
My lord, I am
Okay,
saying
Mr.
my
Rupa
client
Ghosh submits that he has
on instruction.
on
Kindly
instruction
add on
that
instruction.
at present there is no deed of assignment.
There is, I have
No, no, no.
annexed it.
My lord, kindly appreciate.
Or deed
I
of
am saying
assignment
I
is
am giving
registered.
the under
Registered.
Yes.
to myself.
Can be done. You
To
see.
myself.
They will not give effect. This is in the teeth of the order of court.
Okay. In the meantime, if any. Huh?
My lord, kindly ask the court
That
officer to
he
read out the order
submits
your
on
lordship has given.
Instruction that at present there is no transfer made by his clients or by any of the power of attorney holders.
That's right.
ঠিক আছে? However, it is made clear that in the event any transfer be made, that shall not be transferred be made in the meantime shall not be given effect without the leave of the court.
Right. Great.
আর কিছু চাই আর কিছু চাই
Great.
My lord, then there's no requirement of affidavit or is there, my lord, right?
Anyway, matter will be hard out.
Then kindly allow me an affidavit, my lord.
I have put it.
Okay, affidavits must be exchanged in the meantime.
Yes.
By 11th.
Yes. Tomorrow is state.
এই হ্যাঁ একসাথেই করে দেবেন হ্যাঁ 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 সব একসাথেই হবে 5, 9 আর 12 একসাথেই অর্ডারটা হবে আর একটা আছে এই যে সুচন্দা ভুটুরিয়া না ওটা বললো 2টোর সময় থাকবে হ্যাঁ না সুচন্দা ভুটুরিয়া তো পাঠার লেখা রয়েছে ও রাখা হয়ে গেছে ওটা কত তারিখে জাজমেন্টে রাখা হয়েছে ও সুচন্দা ভুটুরিয়া হয়ে গেছে রাইট ওই রাইট এটা ফর জাজমেন্ট হয়ে গেছে